No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, Negotiation Ethics for Lawyers, Even More Negotiation Dirty Tricks and How Best to Respond. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. This is the latest installment in our Negotiation Ethics for Lawyers series of programs, where we examine the legal ethics rules that govern lawyers when we negotiate in a fun and engaging way. Namely, by looking at even more dirty tricks that the other side might use against you in your next negotiation, and suggesting ways you can legally, ethically, and strategically respond to those tactics. This is the 8th program in our series, so if you enjoy it and you're eager to learn more, there is a lot of other content waiting for you, and you likely can find most of those other programs on the same service where you are viewing this one. That said, today's program is meant to stand on its own, so you don't need to have seen any of our prior programs in this series in order to benefit from our discussion today. In fact, our program today will include a thorough discussion of the law and the legal ethics rules that govern lawyers when we negotiate, so you will receive all of the background that you need in order to evaluate the dirty tricks that we will be discussing. We'll also include some negotiation strategy in our program today, but of course, entire books have been written on the topic of negotiation strategy. Starting with the seminal work, Getting to Yes by Roger Fisher and Bill Urey. So if you are looking for more in that area, I do suggest you read that book in addition to watching some of our prior programs in this series, where we incorporated more negotiation strategy into the discussion. In general, we'll follow a 3-step approach to our analysis. First, we'll examine the dirty trick in detail to show you exactly what the trick is, to make sure you can spot it in a future negotiation, and also to show you why it can work so well, if you don't know how to counter it effectively. Second, we'll determine whether the dirty trick violates the law or the legal ethics rules that govern lawyers when we negotiate. Third, we'll discuss some ways you could respond to the dirty trick that not only comply with your legal and ethical obligations, but that are smart moves for you to make in terms of overall negotiation strategy. My goal is to give you the tools and advice you need to feel more comfortable and confident going into your next negotiation, just in case you find yourself sitting across the table from someone who is trying to use dirty tricks or other bad faith tactics on you. With that background, let me introduce the fun hypothetical negotiation between lawyers that we are going to use for today's program. In our hypothetical, we have an aspiring television producer and current coffee shop server, Alfonso Spears, who has an idea for a new reality TV show called Puppy Love.
My concept is that after an eccentric widow leaves her fortune to her prize labradoodle Kiki, 6 contestants compete to win Kiki's love, and with it, her $5 million inheritance, and like all good treatments and pitches, it ends with hilarity ensuing.
Ricky, aka Slick Rick Stratton, owns an upstart reality TV production company, Silver Spoon Productions. Flush with success from his breakout hit, Your Dingo Ate My Baby, Rick is always sniffing around for his next project.
Over a decaf, skinny, no foam latte, I invite Alfonso to pitch Puppy Love, and I accept a detailed written treatment from Alfonso.
Not entirely surprisingly, Alfonso never hears from Rick again, and that fall a show called Dog's Best Friend premieres on the Animal Network. The show, which is produced by Rick and Silver Spoon, is oddly similar to Alfonso's concept for Puppy Love. What does Alfonso do? He hires Kate Summers, who is an industry litigator and a self-proclaimed legal pit bull, to represent him in this dispute with Silver Spoon.
In a barking letter, I accuse Silver Spoon of stealing Alfonso's idea for Puppy Love and insist that Alfonso receive proper creative credit on Dog's Best Friend, a salaried producing job, and a healthy share of the show's profits.
Silver Spoon is represented by its sole in-house lawyer, Edward Stratton III, who happens to be Slick Rick's brother.
I counter that Dog's Best Friend was created independently from Puppy Love, and the similarities aren't enough to state a legal claim against Silver Spoon anyway.
Kate and Edward are now negotiating to try to resolve this dispute between Alfonso and Silver Spoon. Lastly and importantly, while each is an industry veteran, they do not deal regularly with one another. This touches on something that we'll cover in more depth later, but we've purposely created a situation where these folks are not going to deal with one another often. And the reason we've done that is because you tend to see sharper practices when negotiators are not concerned about facing one another later. Obviously, to the extent that these people deal with one another regularly, their conduct would be probably more circumscribed, more reasonable. They would be more concerned about their reputations. They would be concerned about any deceptive practices not being effective and therefore preventing them from competently representing their clients. So it's important to note that they don't expect to see each other again, and I think that's going to explain a lot of the conduct that we see in the hypothetical. Let's take a look at the first scene.
It's nice to meet you, but are you sure you want to handle this negotiation instead of sending it to outside counsel? Intellectual property cases are complex, and I'm not sure that someone like you who doesn't have any litigation experience is up to the task.
What's going on in this scene is a negotiation dirty trick known as intimidation or personal attacks. And it's pretty common to see it used by shady negotiators right off the bat to try to knock the other side off their game before the negotiation begins. Kate's goal here is to unnerve Edward and to get him thinking that maybe he doesn't have the right experience to handle this negotiation with Kate, and thus may begin to doubt whatever negotiation strategy he is planning to employ. While Kate asks whether Edward wants to send this matter to outside counsel because they would do a better job, that is in reality the last thing she wants if she truly thinks Edward doesn't know what he is doing. Kate would rather take advantage of Edward's lack of experience, even though she asks whether he wants to have the negotiation handled by someone else. If you've negotiated before, you've probably experienced some flavor of intimidation or personal attacks being employed by the other side. Kate's attack is reasonably subtle. She disguises it a bit by raising the possibility that Edward might bring in outside counsel before she calls him inexperienced, and depending on the negotiators you've faced, you might have experienced more overt efforts at intimidation. For example, if you're a younger lawyer, the other side might have asked you, "How long have you been practicing?" From where I sit, you still seem wet behind the ears, or perhaps the opposite if you are an older lawyer. "Wow, are you still practicing law? I thought you'd be retired by now." Making personal attacks based on the other side's age or lack of perceived experience are common tactics used by some shady negotiators. Of course, some negotiators might go even further by attacking the other side on the basis of a protected characteristic like sex or race or disability as a means of seeking to intimidate the other side. So you should think of all of those possibilities when we are talking about using intimidation or personal attacks as dirty tricks in a negotiation. Now that we have identified the dirty trick and described it well enough so you can spot it in a future negotiation, and also so you understand why Kate is using this tactic and what she hopes to gain by it, let's talk about whether this tactic violates the law or the legal ethics rules. Starting with the law, the question that Kate's conduct raises is a basic but also a fundamental one. Do lawyers have a duty to negotiate in good faith? Most people would agree that using intimidation or personal attacks in a negotiation is the opposite of negotiating in good faith. But does the law require lawyers to negotiate in good faith? The short answer is no. The longer answer is that in general, in the United States, there is no independent duty to negotiate in good faith because neither the law nor the legal ethics rules require the parties to negotiate in good faith. We do need to distinguish a few things. If you're under a contractual duty to negotiate, let's say you have a first negotiation provision in a contract or a duty to negotiate an extension, for example, the law would imply a duty of good faith in the performance of that contractual obligation. As we all remember from first-year contracts, the law implies a duty to perform all contractual obligations in good faith, which then would include contractual duties to negotiate in cases where such a duty is part of the contract. But that's a specific case, and absent that, there is no general duty to negotiate in good faith. Now that said, there are two caveats to this. The first is that for California lawyers, the California State Bar adopted a set of civility guidelines entitled California Attorney Guidelines of Civility and Professionalism back in 2007. Section 18 of the guidelines addresses the conduct of lawyers when we negotiate, and it provides that, quote, an attorney should negotiate and conclude written agreements in a cooperative manner and with informed authority of the client, end quote. Section 18 follows this general pronouncement with additional guidance that identifies several specific examples of behaviors it advises lawyers to avoid when negotiating, including Section C, which states that, quote, an attorney should avoid negotiating tactics that are abusive, that are not made in good faith, that threaten inappropriate legal action, that are not true, that set arbitrary deadlines, that are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, or that do not accurately reflect the client's wishes or previous oral agreements. End quote. Accordingly, Section 18 of the guidelines suggests that lawyers should act in good faith when they are negotiating, but that is not something that's binding on lawyers even in California. The ethics rules, as we'll see in a second, are the things that bind lawyers, not these aspirational guidelines. The second caveat is that we're talking here about United States law and law in the various 50 states. In some European jurisdictions, and in China, for example, there can be a general duty to negotiate in good faith. Setting those caveats aside, the fact that there is no general duty to negotiate in good faith is a point that's very often misunderstood among lawyers and even some judges. Lawyers often levy charges against one another of negotiating in bad faith, but usually they're just describing some conduct that they don't like or that they find takes a sharp edge, and they are not talking about a violation of some independent duty to negotiate in good faith. There is no independent duty absent a contractual obligation to do that in the United States. This may surprise some of you, and it is a fundamental learning that you should take away at the outset. Now, that is not to say that I think lawyers should negotiate in bad faith. On the contrary, I think it's a better practice to negotiate in good faith because in most cases, in my experience, you're going to have a better result if you do negotiate in good faith. You're going to form better relationships. You're going to have better encounters with those people later. The contract is more likely to go smoothly if the process has gone smoothly. If you're engaging in bad faith in a negotiation to try to gain an unfair advantage like Kate is trying to do with Edward here, that may not produce A, the best agreement, or B, a durable agreement. In other words, an agreement that isn't going to be challenged later, that isn't going to be the subject of a claim, or that just isn't going to be performed well by the side who feels that they were taken advantage of by some bad faith negotiation. You also risk doing significant damage to your reputation if you negotiate in bad faith, and that can negatively impact your ability to get deals done in the future, which is yet another good reason to avoid negotiating in bad faith, using dirty tricks, or engaging in other sharp practice when you negotiate. This is another topic we'll explore in more detail later. So, if there is no general duty to negotiate in good faith imposed by the law or the legal ethics rules, what are the binding rules that govern lawyers when we negotiate? The place to start is with the ABA model rules, which are now followed by the vast majority of states, including California and New York, and specifically ABA Model Rule 8.4, which provides that, quote, it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, end quote. The way I think of this is, in being a zealous advocate for your client when you negotiate, you're not allowed to lie, which is to say you're not allowed to make a false statement of material fact or law. You're not allowed to commit fraud, you're not allowed to commit deceit, you're not allowed to misrepresent. This is very important, and lawyers need to know that if you are engaging in this conduct when you negotiate lying, misrepresenting facts, being deceitful, you are violating the legal ethics rules and could subject yourself to discipline. You also could open up your client to an action for fraud. This is also a good place to make a distinction between the ethics rules and a cause of action for fraud or for misrepresentation or deceit. We're going to look at some hypotheticals and analyze them to see, okay, have you arguably violated your ethical duties and what might be the remedy for that? One other thing to worry about is a possible cause of action for fraud. If you've committed an act in a negotiation, whether it's an ethical violation or it isn't, the other side could sue your client for fraud. They could make a claim that you've made a false statement, that it was material, that they relied upon it to their detriment, and that they've suffered damages. In some cases, fraud can even be a basis to rescind the agreement the parties reached, because there's always the possibility that the other side could bring a fraud claim based upon your conduct in a negotiation. I would urge you to follow the guidance that I'm presenting to you today. Another important thing you should be concerned about if you lie, misrepresent facts, and act deceitfully in negotiations is your reputation. You're going to be dealing with a lot of the same people in your practice over and over again. I work in Los Angeles, and you might think, well, that's a huge metropolitan area. I'm sure there's hundreds of thousands of lawyers, but in reality, it's a pretty small community when you are talking about the entertainment industry. It's rare that I deal with somebody that I don't know or where I don't know someone who knows that person. And if you get a reputation in your community for sharp practice, that could really be a detriment to you and to the clients you represent. Let me explain what I mean. If I'm negotiating with someone who I know has a reputation for sharp practice, I'm going to be extra careful with that person. There might be reasonable accommodations that I would make for people that I deal with regularly who I feel are straight shooters. With some of those folks, I could get a deal done in a day and feel comfortable relying on an email confirmation even before the contract is done because I know and trust them. If I don't trust you, I will make you document every statement you make to me that I can't independently verify before I will rely upon it, and that process can take a very long time. I'll also likely take a harder line against you if I believe you are a shady negotiator, because I expect you will be doing the same in your dealings with me. If this type of negotiation takes longer than your client wants and ends up delivering less value to your client than another lawyer could have obtained, you will end up being less effective for your client precisely because you have a reputation for sharp practice. Our next stop is a critical rule for lawyer negotiators, ABA Model Rule 4.1. Here is what the rule says, quote, "In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact to a third person, when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, end quote." The language starts, "In the course of representing a client, a lawyer shall not knowingly." Then we have a couple of examples of things that the lawyers may not do. Let's look closely at the language used in the rule because each of the words turns out to be quite important. One key word here is knowingly. The rule provides that, quote, "A lawyer shall not knowingly make a false statement of material fact or law to a third person in Section A, and then in Section B, knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client," end quote. If a lawyer did not know a statement of fact or law was false at the time he or she made it, that conduct would not violate ABA Model Rule 4.1. We're also only talking about false statements of fact or law. We're not talking about opinions. So, this pie is really good, is going to fit into one category, and there are 3 pieces of pie when there are, in fact, 4 is going to fit into a different category. And as simple as that example may sound, I think people would be surprised at how often opinions are confused with statements of fact. And it's not just any type of statement of fact. It has to be a material fact. So it may well be I'm happy to negotiate with you, but I have an appointment today at noon. If that's untrue, is that a statement of material fact, or is that really a statement about the context? Is that a statement about something that's not material? It may be a very bad idea for me to lie about an appointment to delay the start of our negotiation in terms of our relationship, but at the same time, is that going to be grounds for an ethical violation? I think people would argue that that kind of statement is not material. Returning to our hypothetical and applying the standards that we just reviewed, I think it's pretty clear that Kate's conduct using intimidation and making personal attacks isn't a violation of either the law of fraud or the legal ethics rules. For both potential fraud claims and legal ethics violations, the first question to ask is, does Kate make any material false statements of fact? If you look closely at what Kate said, quote, "It's nice to meet you, but are you sure you want to handle this negotiation instead of sending it to outside counsel? Intellectual property cases are complex, and I'm not sure that someone like you who doesn't have any litigation experience is up to the task," end quote. Kate isn't making any statements of fact at all. She's asking a question, albeit a loaded one, and then expressing an opinion about whether Edward has the right experience to handle this matter. Neither the law of fraud nor the legal ethics rules is going to punish a lawyer for employing such a tactic in the context of a negotiation, even if Edward ends up making a bad deal with Kate because her intimidation tactic worked. Because neither the law nor the legal ethics rules would afford Edward any remedy, it's important that Edward know how to counter Kate's tactics in the negotiation, which is a topic we'll turn to next. Now, Kate's tactics here are very different from a case where a lawyer makes a false statement of material fact. For example, telling the other side that the car you are selling hasn't been in any accidents when in fact it has. That could form a basis for fraud or a legal ethics violation under ABA Model Rule 4.1. So Kate isn't risking catching a fraud claim for her client or a violation of the legal ethics rules for herself in this first hypothetical. But what if Kate were attacking Edward based on a protected characteristic such as his age or sex? In that case, Kate might have a problem under the legal ethics rules. Turning back to ABA Model Rule 8.4, that rule was amended a few years ago to include Section G, which states as follows, quote, "It is professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law." This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules, end quote. Accordingly, if Kate had attacked Edward on the basis of his age or sex or another protected characteristic, Kate very likely would have violated ABA Model Rule 8.4G. In addition, as we saw at the start, Kate also would have violated Section 18 of the guidelines. But remember that the guidelines are aspirational only. They are not binding on lawyers, and they cannot form the basis for discipline or a finding of legal malpractice. Let's turn now to consider how Edward might respond to Kate's tactics. Let's take a look at one possibility.
I appreciate your concern, but I can't see why my client should spend any money on legal fees for a case that has no merit. You don't seem like the sharpest tool in the shed, so I think I'll be more than fine.
Edward's response here could be described as fighting fire with fire or responding in kind. He is responding to Kate's personal attack and intimidation by making a personal attack of his own. While Edward's response wouldn't violate the law or the legal ethics rules for the same reasons that Kate's conduct doesn't violate the law or the legal ethics rules, I wouldn't recommend this as a response for a couple reasons. First, it likely will inflame the situation, and if this pattern of personal attacks continues, it very well could result in the negotiations being terminated by one of the participants. If the parties could have reached an agreement to settle the dispute that is better for both parties than moving forward with litigation, their choice instead to use dirty tricks and bad faith negotiation tactics have done a disservice to their respective clients who are left worse off with that result. Second, while personalities and emotions can never be removed completely from any situation, including any negotiation, it's generally good advice in a negotiation when personalities or emotions start to take over to try to separate the people from the problem. This is sage negotiation advice that comes directly from the classic book Getting to Yes by Roger Fisher and Bill Urey that I mentioned in the introduction. I was fortunate enough to have Roger Fisher as a professor at Harvard Law School before he passed away, and to take his course on negotiation theory and strategy. Among Professor Fisher's many insights were that there are 4 fundamental concepts at work in successful negotiations, and the very first one is to separate the people from the problem. The second one is to focus on interests, not positions. What do we mean by that? When a party comes up and says, "My client wants X," X is not their interest. X is their position. It's based on some underlying interests that they probably haven't articulated very well. When someone comes up and says, for example, "I need $1 million to settle," that's a position. Probably not a position most people are going to want to live with. What you need to do is try to understand the interest. Help me understand why your client's making that demand. What can you tell me about that demand? Where is this coming from? These types of questions will help discover the underlying interest. In many cases, If you identify the underlying interest in this case, it might be financial stability, it might be respect in the community. You can think about other more creative ways to try to meet that interest without having to accept the position that they've articulated. The third concept is inventing options for mutual gain. I know that sounds pie in the sky, and in some situations, you may feel that your negotiation is completely zero-sum and that there's no way to have mutual gain. But in general, rather than taking a purely distributive mindset, for example, thinking that there are 10 $1 bills on the table and we have to distribute those 10 bills somehow, and I would like to have 6 and you to have 4, and you would like for me to have 4 and you to have 6, where you end up spending a lot of time trying to get close to something that's 5 to 5. What does it mean instead to invent options for mutual gain? It means try to figure out how to turn the $10 in the middle of the table into $12. Then we can each have $6. It takes hard work and creative thinking. I think that people dismiss that idea too quickly because it's hard work. And they're so focused on what's in the middle of the table that they don't think about other things that can be brought in. Typically things that I may value less than you value. If I value something in a way that's lower than the way that you value it, now we can trade because there are probably things on the other side as well that you value less than I do. That's the classic win-win situation. Easy to talk about on paper, but sometimes people use that as an excuse not to try. I've found that putting the effort into that very often bears fruit. The fourth concept is to insist on using objective criteria. You can imagine examples where you're going to have disagreement either during the negotiation or during the performance of the contract, where a more subjective standard or looser contract language is going to cause you to talk past one another and have disputes. We'll see this later when Edward references other cases he has handled but won't reveal any of the specifics. Insisting on objective criteria, both in the negotiation and in the agreement itself, is a good way to make sure you are not being deceived and that the agreement you reach will be performed by the other side. This is just the tip of the iceberg in terms of valuable negotiation strategy that you will find in Getting to Yes, and I would highly recommend that you read it in addition to viewing some of our other programs if you are interested in negotiation strategy. If you've been in more than a few negotiations in your career, I think we've all seen examples where emotions are running high. There may or may not be history between the parties, and people's styles are not meshing well. And you end up having a situation in a negotiation where the participants end up unduly focused on the people involved, maybe the principals, maybe the negotiators, or both, such that they're not thinking about the problem just as a problem to be solved and really sitting down together and trying to solve it. It becomes more about scoring points against one another, or in our hypothetical trading insults. Obviously, that's not going to be productive. And so when you find yourself getting carried away with the people or the personalities and the psychology of it, sometimes it's helpful to simply set that aside and try to think about the problem. Ultimately, those emotions are going to be relevant. You can't ignore them, but it's helpful to at least start with the problem and then think about how the personalities influence the way that you address the problem, and to try to keep the two separate. That's good advice, and that's another reason Edward probably shouldn't respond to Kate's personal attacks with personal attacks of his own. Let's take a look at another possible response.
You're right. I never worked as a litigator. Lawsuits always seemed so pointless and wasteful that they never interested me very much. But from what I hear, you're not only a very skilled litigator, but also a very reasonable one. If that's true, I am hopeful that if we put our heads together and focus on the problem, we can find a solution that works for both of our clients.
This is a much better response, and it dovetails nicely with the advice to try to focus the negotiators on the subject matter of the negotiation as a problem to be solved together instead of focusing on the people who are involved in the negotiation. Flattering the other side is itself a negotiation tactic, but in the context of Edward's response here, he's using flattery to counter Kate's aggression, as opposed to employing it as a standalone tactic designed to curry favor with the other side. In any case, this response is a much better choice for Edward, because not only does it serve to lower the temperature in the room, it focuses the parties on discussing the merits of the dispute to see if a settlement is possible. In that way, it avoids the worst-case scenario where a mutually beneficial agreement is possible, but the parties fail to get there because the negotiations are terminated prematurely by one party or the other. Of course, this response by Edward is also perfectly legal and ethical, in addition to being a wise move strategically. Let's move on now to our next hypothetical.
Before we start, we need your agreement that any settlement will include a full release of Silver Spoon, Rick Stratton, and all of our other officers, directors, and employees. Because a broad release is customary in these cases, we shouldn't have to give you anything to get that basic understanding.
Whether cherry-picking or nibbling qualifies as a negotiation dirty trick or not is in the eye of the beholder, so let's focus on it as a tactic designed to get the other side to agree to certain points in a piecemeal fashion. This is the opposite of putting all of the material deal points that are at issue in the negotiation out on the table and discussing them holistically. Think about writing down your position on all of the material deal points in a formal term sheet and sending that to the other side and saying this is what we're prepared to agree to. Then the other side will mark that up and send it back with what they are willing to agree to on each of the material deal points, and maybe even adding a few new ones for you to consider and on which to state your position. In either case, the parties are negotiating over a known universe of issues and are making proposals and counterproposals that address all of those issues as a package deal. Cherry picking is where one party tries to secure the agreement of the other party on a specific material deal point, like the full release Edward is seeking here as a standalone item, and without agreeing to all of the other material deal points that would make up an agreement to resolve the dispute. Strategically, Edward is trying to get Kate to pre-agree that his clients will get a full release before he has offered anything in return, including any payment to Alfonso as consideration for agreeing to resolve Alfonso's claims. Needless to say, you don't want to let yourself be cherry-picked in a negotiation, either at the outset of the negotiation as Edward is attempting to do here, or at the end of the negotiation when you think you've got a deal and the other side raises just one more thing that they need in order to agree to the deal. When cherry picking is used in that way, it usually is known by a different name, nibbling, and it's similar in that the other side is raising a new issue that they want you to agree to without getting anything in return in order to agree to the deal that is currently on the table. So whether we are talking about cherry picking or nibbling, is Edward's conduct legal or ethical? Applying the law and legal ethics standards we reviewed earlier, the first question to ask is, does Edward make any material false statements of fact? Let's look closely at what Edward said, quote, "Before we start, we need your agreement that any settlement will include a full release of Silver Spoon, Rick Stratton, and all of our other officers, directors, and employees." Because a broad release is customary in these cases, we shouldn't have to give you anything to get that basic understanding, end quote. The first statement is a request or a demand and not a statement of fact. The second statement, that a broad release is customary in these cases, is a statement of opinion and not of fact. Now, you could argue that the second statement is a statement of fact, and even if you are right, it's not false because broad releases are in fact customary in settlement agreements. So Edward isn't committing fraud or violating the legal ethics rules by cherry picking or nibbling here. Is it bad faith negotiation in violation of Section 18 of California's non-binding civility guidelines? While you could find a violation of the admonition to negotiate in a, quote, cooperative manner, end quote, or to avoid tactics that, quote, are not made in good faith or that are intended solely to gain an unfair advantage, end quote, set forth in Section 18 of the guidelines, it doesn't really matter because those guidelines are purely aspirational and not binding on lawyers. You can choose to follow the guidelines or not, but you can't use a violation of the guidelines as a basis for making a disciplinary complaint against another lawyer. Nor is there a judge or a state bar official present in your negotiation to enforce the guidelines or the law or the legal ethics rules for that matter. So you are on your own to deal with bad faith conduct of the sort that Edward arguably employs here. Thankfully, that's not hard to do once you've had a little training in negotiation strategy. Let's take a look at one possible response Kate could make.
That's fine, but one thing we can't agree is to keep any settlement we may reach confidential. Alfonso is just starting out in his career in the industry, and he needs to be able to talk about the key role he played in creating Dog's Best Friend as part of his producing resume.
Similar to Edward's first response in our first hypothetical, this is Kate responding in kind with a cherry pick of her own. She's trying to get Edward to agree at the outset that any settlement they may reach won't include a confidentiality provision. Kate is using this tactic for the same reason Edward employed it, to get him to pre-agree to it in advance of the actual negotiation, plus the additional reason that she is using it to counter the same tactic Edward is using against her. In this case, I don't hate the idea of Kate going tit for tat with Edward because it shows that she is an experienced negotiator in her own right and is well versed in how the game is played. If her smooth use of a negotiation tactic to counter Edward makes Edward realize that he isn't going to be able to take advantage of Kate in this negotiation, that will be a benefit to Kate whether or not Edward agrees not to include a confidentiality provision in the settlement agreement. For the same reasons that Edward's use of this tactic didn't violate the law or the legal ethics rules, Kate's decision to fight fire with fire isn't going to be a problem for her. But let's say we tweak the hypothetical a bit. What if Kate is misrepresenting Alfonso's true goals or objectives when she takes the position that Alfonso can't or won't agree to keep the settlement confidential? Let's say Alfonso didn't care about confidentiality and that Kate is taking this position just because she thinks Silver Spoon can't or won't agree to it, with the plan to give it up later in return for something valuable such as more money in terms of the cash portion of the settlement. Would that present a legal or legal ethical problem for Kate? The answer to that likely is no. To understand why that is so, we need to provide a bit more background in terms of the legal ethics rules that govern lawyers when we negotiate. We know that we can't make material false statements of fact or law, and that we can't engage in dishonesty, fraud, deceit, or misrepresentation, but can lawyers misrepresent their clients' true goals and objectives in a negotiation? You might be surprised to learn that Kate's statement that Alfonso can't or won't agree to keep the settlement confidential, assuming now that this statement is false or at least misleading, likely would be held not to violate the law or the legal ethics rules. In order to understand this result, we need to return to ABA Model Rule 4.1 and more specifically to the comment to that rule. As important as Model Rule 4.1 is, the comment is arguably more important because it is attempting to unravel what it means to not knowingly make false statements of material fact in the context of negotiations. The comment begins by observing that, quote, under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category, and so is the existence of an undisclosed principal, except where non-disclosure of the principal would constitute fraud. End quote. Interpreting ABA Model, Rule 4.1 and the comment, the ABA Standing Committee on Professional Ethics in 2006 issued Formal Ethics Opinion Number 06-439, which provides a lot of detailed guidance for lawyers engaged in negotiations. The opinion states directly that lawyers do not violate the model rules by misrepresenting, exaggerating, or downplaying several independent categories, including a settlement position or a willingness to make concessions, a client's negotiation goals or objectives, the strengths or weaknesses of factual or legal positions, the value of the subject matter of the negotiations, or the lawyer's or the client's confidence in the availability of alternatives. So we have a list of categories of statements that don't violate ABA Model Rule 4.1 according to the ABA Ethics Committee. You likely don't find this guidance surprising because few experienced negotiators believe the other side when they tell you that their client isn't interested in settling for less than $1 million, particularly when you settle the case an hour later for $50,000. But one part of ABA Formal Ethics Opinion Number 06-439 is surprising even to experienced negotiators. The opinion states that, quote, a party's actual bottom line or the settlement authority given to a lawyer is a material fact that a lawyer may not misrepresent in a negotiation, end quote. Similar to a lawyer's statements about a client's settlement position, I think most lawyers don't actually believe it when they hear another lawyer say, my client's bottom line is $4 million. Does anyone ever believe that? The opinion says, and this is important, that a lawyer may, quote, downplay a client's willingness to compromise or present a client's bargaining position without disclosing the client's bottom line position in an effort to reach a more favorable resolution, end quote. So, it creates this distinction between my client's bottom line is $1 million and something like we'd never accept that little money to settle our claims. Applying the standards set out in ABA Formal Ethics Opinion Number 06-439, making a false statement about your client's bottom line violates ABA Model Rule 4.1. I would point out that even though a false statement about your client's bottom line is unethical according to the ABA committee, I don't think it ever could give rise to a fraud claim because I don't think anyone could show reasonable reliance upon that type of statement. Based on the above guidance, Kate does not violate the law or the legal ethics rules by misrepresenting Alfonso's negotiation goals or objectives, and because she never said anything about Alfonso's bottom line in this hypothetical, Kate can't be at risk of violating the legal ethics rules by misrepresenting her client's actual bottom line. I am very confident in this conclusion, but because I am likely speaking to an audience that includes some California lawyers, I need to add some caveats. First, while I am focused today on the ABA model rules, which nearly all states have adopted in some form or another, including California, I need to make a couple of comments about the legal and ethical standards that apply to California lawyers when we negotiate. While California follows the ABA model rules, California has on its books 3 statutes that predate its adoption of the ABA model rules that could be read to impose greater obligations on California lawyers than we find under the model rules. The first statute is California Business and Professions Code Section 6068, which requires, among other things, that an attorney, quote, employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, end quote. The second statute is Business and Professions Code Section 6106, which states that an attorney who commits any act of moral turpitude or dishonesty, whether or not in the course of the attorney's conduct as an attorney, is subject to disbarment or suspension. The third statute is Business and Professions Code, Section 6128A, providing that, quote, every attorney is guilty of a misdemeanor who is guilty of any deceit or collusion, or consents to any deceit or collusion, with intent to deceive the court or any party, end quote. So, while you have the ABA Ethics Committee saying that you don't violate ABA Model Rule 4.1 by making false statements about your client's negotiation goals or objectives, you have statutes in California saying attorneys may employ, quote, those means only as are consistent with truth, end quote, and expressly prohibiting them from engaging in dishonesty or deceit. While I believe the California State Bar and its courts would look at the guidance promulgated by the ABA when judging the conduct of lawyers when we negotiate, particularly now that California has adopted the ABA model rules, you should be aware that these other statutes exist where the language is admittedly vague, but also pretty absolute in requiring attorneys to employ, quote, those means only as are consistent with truth, end quote. The last caveat is, of course, Section 18 of California's Attorney Guidelines of Civility and Professionalism, which we discussed earlier today. While the guidelines are aspirational only, there is little doubt once again that Kate's misleading statements would violate Section 18. Apart from Section 18's general pronouncement that, quote, an attorney should negotiate and conclude written agreements in a cooperative manner and with informed authority of the client, end quote. You also could find fault with Kate's misrepresentations under the language of Example C that advises lawyers to avoid negotiating tactics that, quote, are not made in good faith, that are not true, and that do not accurately reflect the client's wishes, end quote. What else might Kate say in response to Edward's attempt to cherry-pick her on the issue of obtaining a full release?
We're happy to consider a full release as part of settling our claims, but we can't agree to any single deal term in a vacuum. I suggest that we get all of the issues out on the table, including what you are willing to offer my client as compensation for misappropriating his idea for Dog's best friend, so each of us knows exactly what any potential settlement would entail.
I would describe this as the standard and probably the best response when someone on the other side tries to cherry-pick you. Kate wisely suggests that both sides identify what they believe are the material deal points that need to be discussed and agreed in order for the parties to reach a deal. Once all of the issues are on the table, she and Edward can discuss them one by one and try to reach agreement on each one, while reserving their respective agreement on the deal overall until that process can conclude as to each of the issues. In addition, if some of those issues need to be horse traded for others, and horse trading is not something that I recommend doing as an alternative to reaching a compromise on each individual issue, as a matter of general negotiation strategy. But in real-world negotiations, some horse trading almost always happens as a way to bridge the final gaps between the parties. At least both Kate and Edward know that when they are trading horses, there aren't more horses out in the pasture that the other side will later insist be handed over as part of the deal. Finally, Kate's response is also smart because she styled it in terms of jointly working the problem. Quote, I suggest that we get all of the issues out on the table so each of us knows exactly what any potential settlement would entail, end quote, which is a good way to frame the negotiation as we discussed earlier. It's harder to reach a deal if the participants see the negotiation as a contest where the goal is to win more points than your opponent, as opposed to a joint problem to solve. A negotiation is successful if the deal that is reached is better for both parties than the alternative. It doesn't matter how many points you get or how many points the other side gets, and needlessly focusing on that can prevent you from reaching that mutually beneficial deal. Let's turn now to our final hypothetical.
I've been doing this for more than 30 years, so I've seen it all in terms of claims people can make against a TV studio. Silver Spoon has never paid more than $25,000 to settle any claims against it, and I don't plan on starting now.
As you can see from the slide, the ethical issue here is that Edward is simply lying to Kate when he says that Silver Spoon has never paid more than $25,000 to settle claims against it, when in fact, Edward has settled more than a dozen cases for at least $100,000 in payments in each case. Lying is probably the oldest negotiation dirty trick there is, and so there's not much mystery in terms of identifying what is going on here. It's important to note, though, that the fact Edward is lying about settlements Silver Spoon has reached in prior cases is a material fact because what other cases against Silver Spoon settled for would be important to Kate in deciding whether to settle Alfonso's claims here and what amount it is reasonable for him to accept in terms of a cash payment. Because Edward personally was involved in these prior cases, it's also clear that his false statement of material fact was knowingly made. You can imagine Edward being more careful in terms of how he could try to make the same point, such as I can't remember settling any cases for more than $25,000, or instead of saying Silver Spoon has never paid more than $25,000, he could have said we'll never pay. And in those versions, he would leave himself some wiggle room to argue that he isn't making a false statement of material fact. But in our hypothetical, Edward makes a definitive statement and settlements in prior cases, and it's clearly false and clearly material. There also is no doubt that Edward is making this statement in an effort to influence Kate's opinion of the value of Alfonso's claims in an effort to achieve a better settlement for Silver Spoon, which is why most people lie in negotiations. That is, in an effort to achieve a better outcome for their client at the expense of the other side. Is Edward's conduct ethical? Of course not. Edward's knowing lie about a material fact is a clear violation of ABA Model Rules 4.1 and 8.4, plus a potential claim for fraud in the event Kate chooses to settle Alfonso's claims in reliance on Edward's false statements. Although Edward would dispute that Kate's decision to rely solely on his statements about other cases he has settled, rather than asking to see the proof, was reasonable. What about Section 18 of the guidelines? Lying to the other side is probably the clearest example of a tactic that violates the standard to, quote, negotiate cooperatively, end quote. Lying also violates several of the examples listed in Section 18, including, quote, to avoid negotiating tactics that, quote, are not made in good faith, are not true, and are intended solely to gain an unfair advantage, or take unfair advantage of a superior bargaining position, end quote. Accordingly, in this example, we have conduct that clearly violates the law, the legal ethics rules, and Section 18 of the guidelines. In addition to these violations, Edward is also doing severe and irreparable damage to his reputation by lying in a negotiation. As I mentioned at the outset, even in large metropolitan areas, the community of lawyers working in a particular industry is usually quite small, and it's rare that you're negotiating with someone who you don't know or who someone you know has dealt with before. It's relatively easy to find out someone's reputation in these small communities, and if you get a reputation for lying, using dirty tricks or other sharp practice, that reputation will follow you, and it can make it much harder for you to represent your clients effectively in future deals. If the other side knows you have a reputation as a dodgy negotiator, they will take extra precautions in dealing with you. They likely will take a harder line against you because they assume you are doing the same with them. They likely will require you to verify and document everything you say in the negotiation, which takes more time and sometimes it cannot be done at all. In my experience, shady negotiators are not as good at lying or using dirty tricks as they think they are, and more often than not, they end up with worse deals simply because they have a reputation for lying or other sharp practice. Edward would be better served by playing it straight, even if he wants to take a hard line in this negotiation, than lying as he does here. This is true separate and apart from creating potential exposure for himself under the law and the legal ethics rules solely because of the reputational damage he will suffer and what consequences often flow from that. How might Kate respond to Edward's statement if she suspects that he is lying to her? Here are two very smart things that Kate could say in response to Edward's lies, each of which is legal, ethical, and would not violate the guidelines.
Is that right? What cases have you settled most recently? What were the claims in those cases? And how much did you pay to settle each of them?
What Kate is doing here is asking for specifics. That's a great way to force the other side into making a material false statement, or in this case, more material false statements, if Edward chooses to double down on his lies and starts making up cases where he has settled claims for less than $25,000 and describing those fake cases to Kate in response to her questions. It's always a good idea in negotiations to ask a lot of questions. This is generally true because it helps you uncover the interests that underlie the positions the other side is taking. For example, can you explain why you are asking for X? Which helps you to find alternatives that satisfy those interests if you are not prepared to give the other side X, as we saw when we talked about the general negotiation advice, to focus on interests and not positions, but is particularly important when you think the other side is lying to you or engaging in other sharp practice as Kate is doing here. One thing Edward likely will do if he is smart, in addition to being unethical, is to respond that he can't talk about any of the prior cases because those settlements were confidential. Let's take a look at that response.
I'd love to tell you about those cases, but as I'm sure you can appreciate, those cases were settled on terms that included strict confidentiality clauses, so I can't share any of the terms with you.
Of course, it's possible and probably likely that Edward is telling the truth here. Settlement agreements usually contain confidentiality clauses that prevent either party from disclosing the terms of the settlement to any third party absent a subpoena or some other court process. So this is likely to be a roadblock you will encounter in your negotiations if you use the technique of asking for specifics when the other side starts to reference other deals or settlements. Thankfully, there is a very good stock response that you can give when that happens. Let's take a look at that response from Kate here.
I understand your position, and I assume you will understand mine, which is that I cannot rely on anything you tell me about settlements in prior cases that I can't independently verify. If you can't provide copies of the settlement agreements, we'll just leave them out of our discussion.
It's a key rule in negotiations that you shouldn't ever rely on something the other side tells you if it's important, unless it's something you can independently verify. This is following the general negotiation advice to insist on objective criteria that we discussed earlier. If you stake out this principle as Kate does here, you can use that standard to rebut any arguments the other side is making that rely on something facts, terms in other deals, industry standards for which they are unable for whatever reason to support with evidence that you can examine for yourself. Kate does a good job of this here, and it's a great way to respond when the other side is referencing other cases or deals in an effort to move you off of a position you are taking while at the same time refusing to prove up the specifics of those other cases or deals based on claims of confidentiality or some other excuse. Let's take a look at another response Kate could make.
I find that hard to believe, but whatever you've done in past cases where I wasn't representing the plaintiff isn't relevant here. I just settled a very similar idea theft case against a major motion picture studio for more than $1 million, so that's what you're going to need to pay if you'd like to avoid litigation in this case.
Kate's response here is fine, as long as what she is saying about settling another similar case for over $1 million is true. Otherwise, she'd be guilty of lying to Edward just like Edward is doing to her. Of course, I don't recommend lying in response to lying by the other side in a negotiation because lying is unethical, and there is nothing in the law of fraud or the legal ethics rules that excuses your lies on the basis that you were forced to lie in order to fight fire with fire. Kate's first response is a much better one for the reasons we just discussed. Let's take a look at one final possibility.
Well, I guess there is a first time for everything, because Alfonso's bottom line is $500,000 to settle his claims. If Silver Spoon is not prepared to meet that demand, I guess we don't have anything more to discuss before we file our lawsuit.
Kate's response here is risky because she chooses to disclose to Edward her client's bottom line settlement position of no less than $500,000. As we saw earlier, ABA Formal Ethics Opinion Number 06-439 states that, quote, a party's actual bottom line, or the settlement authority given to a lawyer, is a material fact that a lawyer may not misrepresent in a negotiation, end quote. It would be better if Kate had said something like, there is no way my client would accept less than $500,000 to settle his claims, which is a statement of her client's intention toward a possible settlement, and therefore something she likely is allowed to misrepresent, versus speaking in terms of her client's bottom line. If Kate's statement is truthful, that is, if Alfonso had expressed to her that his bottom line in fact is $500,000, she should be okay, but it's needlessly dangerous for her to speak in terms of bottom lines when any number of other statements will convey the same negotiating position with less risk of violating the legal ethics rules. As a result, I don't recommend this kind of response by Kate because there are many other similar statements that would work just as well. We're very close now to the end of today's program, where we learned a lot about the law and the legal ethics rules that govern the conduct of lawyers when we negotiate. We've seen the general rules that require lawyers to be candid in their dealings with others. That's ABA Model Rules 8.4 and 4.1. These rules establish clear bounds that you must stay within, such as the prohibition on misrepresenting your bottom line or the settlement authority that you have been given. In practice, lawyers can and should speak of their client's inclination toward a potential agreement and not his or her bottom line. What else have we learned that is clear in this area? The rules do not expressly bar attorneys from misrepresenting facts or law if they are not material. The rules also don't prevent attorneys from misrepresenting their opinions or intentions or state of mind. The rules do not preclude lawyers from misrepresenting their settlement positions or willingness to make concessions. If you hear an attorney claim that their client is not willing to make any concessions, you can hear that and know that it very well may be misrepresented. This brings us back to ABA Formal Ethics Opinion Number 06-439, which says that the lawyer you are opposing may, without violating the ethical rules, misrepresent her client's goals, the client's objectives, the strengths and weaknesses in the client's position. The value of the subject matter may also be misrepresented to you, and the lawyers you're facing may also misrepresent their confidence in the availability of alternatives. Finally, apart from the legal ethics rules, there is the law of fraud that would allow the other party to make a claim in cases where the lawyer on the other side in a negotiation made false statements that were material, and upon which the other party relied to their detriment and suffered damages. We also learned about the existence of a set of civility guidelines entitled California Attorney Guidelines of Civility and Professionalism that the California State Bar adopted in 2007. Section 18 of the guidelines addresses the conduct of lawyers when we negotiate and advises lawyers that we should negotiate in good faith, which is not otherwise required by the law or the legal ethics rules. The guidelines are purely voluntary. They do not create standards of conduct or care. They do not supplant any rules or laws that govern attorney conduct, and they cannot be an independent basis for imposition of discipline or a finding of malpractice. But they reflect how the California State Bar thinks that we lawyers should practice law. It's up to you whether you think the guidelines are wise or necessary and whether you choose to follow them. As this summary, I think, illustrates, there is a solid body of governing law and legal ethics rules that serves to regulate the conduct of lawyers when we negotiate. At the end of the day, you will decide how to behave when you negotiate, and as I mentioned earlier, potential damage to your professional reputation is something you must consider whenever you might be tempted in a negotiation to use a dirty trick or to engage in other sharp practice. In my experience, dirty tricks and other sharp practices are not nearly as effective as you or your client might think they will be, and this is particularly true if the lawyer on the other side knows how to counter them. And in most cases, you'll only end up disadvantaging yourself and your clients if you get a reputation for being a shady negotiator. I hope you enjoyed today's program and thanks for joining me.